unanimous guilty verdict vanished overnight. $9.4 million in Medicaid fraud, 6.2 tons of narcotics hidden in plain sight, and a judge who destroyed the case with a single ruling. This is the story of how Minnesota's legal system hesitated and how that hesitation exposed a corridor no one knew existed. 4 a.m. Minnesota, a courthouse in darkness. Inside sealed files, a verdict that no longer existed. Heroin moving through warehouse corridors. Fentanyl staged before dawn. Cash withdrawals timed to transport routes. What looked like a Medicaid fraud case was a narcotics operation hidden inside a legal system that couldn't hold the line. If you think this verdict should never have disappeared, comment yes and tap like now. What comes next will expose the system that failed. It began as one of the most airtight fraud prosecutions Minnesota had seen in years. 14 months of financial tracing, 6,700 Medicaid billing records, more than $9.4 million in suspicious reimbursements tied to a network of home care businesses that barely existed on paper. Prosecutors walked into court confident. The jury deliberated less than 5 hours. 12 members, zero hesitation, a unanimous guilty verdict, and then it disappeared. 3 months later, Judge Evelyn Hart issued a ruling that stunned everyone inside the courthouse. She didn't claim the fraud never happened. In fact, she wrote that the spending patterns, cash withdrawals, luxury assets were deeply troubling, but she overturned the conviction anyway. Her reasoning? The state hadn't ruled out the possibility that someone else inside the organization orchestrated the scheme. In one motion, the verdict collapsed. What was supposed to be a clean victory for accountability instead exposed something far more dangerous, a system where even the most obvious case could vanish the moment it reached the bench. Type exposed if you're starting to see how fragile the system really is. The pattern was already there. Long before the verdict collapsed, federal analysts noticed something that didn't fit the profile of routine Medicaid fraud. The businesses at the center didn't behave like failing clinics trying to survive. They behaved like transit points. 3 separate home care companies, same Central Avenue registration address, but none maintained a physical office. Phone numbers recycled, employee rosters overlapped, and in 11 months, more than $2.1 million quietly moved out of Minnesota through regional transfers that stopped just short of international reporting thresholds. The timing raised even more questions. 418 cash withdrawals processed between 1 a.m. and 3:30 a.m. across multiple branches. Precise amounts. Never high enough to trigger automatic review, always large enough to drain accounts before business hours. Each transaction followed the same pattern: temporary balance reset, rapid infusion of new Medicaid reimbursements, then another withdrawal sequence days later. When investigators overlaid the transaction timeline with port of entry logistics data and warehouse rental records across Wisconsin and Illinois, the alignment was impossible to ignore. The same dates that saw peak withdrawal activity matched transport manifests tied to medical supply shipments routed through secondary storage hubs. For the first time, federal analysts stopped asking how the fraud worked and started asking what exactly the money was clearing the way for. Comment: follow the money. If you believe financial patterns tell the real story, the coordinates led somewhere dark. The turning point came when federal analysts stopped treating transactions as evidence and started treating them as coordinates. They reconstructed 11 months of outbound transfers, warehouse lease agreements, third-party contractor invoices, layering every timestamp onto a single operations map. What emerged wasn't random movement or fragmented accounting, it was a route. A clean, repeating line stretching from Minneapolis into rural Wisconsin, then bending south toward 2 storage hubs in northern Illinois that hadn't appeared anywhere in the Medicaid files. Within 72 hours, task force units were on the ground. The first site looked ordinary enough: a low, windowless warehouse tucked behind a grain distribution yard. The kind of place few people would ever notice. But inside, investigators found something no Medicaid case was supposed to lead to: reinforced modular crates, false floor plates, odor-sealed liners, shrink-wrapped containers labeled as youth rehabilitation medical kits. There were 612 crates in total. Only 9 contained medical supplies. The rest were empty or had residue traces that immediately triggered narcotics alerts. Across all 3 facilities, forensic teams documented storage capacity consistent with multi-ton shipment rotation, the kind used to stage cargo for short-window cross-state dispatch. Transport logs were written by the same 2 subcontractors. Departure windows matched the early morning withdrawal cycles within minutes. And in one of the Illinois hubs, investigators recovered 17 sealed drums hidden behind a false partition, each bearing a serial code tied to a logistics broker already flagged in an unrelated DEA inquiry. Lab testing confirmed it within hours. Fentanyl, high purity, bulk stage. The estimates stunned the room. Analysts projected that over a 2-year cycle, the network could have processed the equivalent of 6.2 tons of narcotics through those staging points alone. This was no longer a fraud inquiry. It was a corridor disguised as compliance. If you believe this was never just fraud, comment network and tap-like. The operation went federal. At 4:18 a.m., Federal Command authorized a coordinated sweep, 3 simultaneous entry operations. Highway choke points activated, carrier vehicles immobilized before dawn traffic could disperse. Agents seized $38 million in logistics assets, encrypted manifests, handheld inventory scanners that revealed something even more unsettling. Outbound shipments had been cataloged under philanthropic and healthcare export codes, allowing them to move through inspection lanes with minimal scrutiny. The money hadn't merely been stolen, it had paved a path. And for the first time since the verdict vanished, investigators understood why the financial pattern felt deliberate. It wasn't supporting a lifestyle or a shell company, or even a fraud scheme trying to stay alive. It was clearing the way for something far larger and far more organized than anyone inside the courthouse had ever imagined. Type infrastructure, if you see how deep this really goes. The network was designed to survive. What investigators uncovered inside the warehouses didn't close the story. It widened it. The crates, manifests, encrypted inventory logs didn't belong to a single business. They belonged to a lattice of entities, built, layered, rotated over time. A system designed not merely to move money or goods, but to ensure that no single failure point could expose the whole operation. When forensic accountants pulled the registration history of companies tied to Medicaid reimbursements, they found none were truly independent. 11 business entities spread across 6 legal owners, incorporated within a 32-month window, each tied to a different sector on paper: youth services consulting, elder home care support, international relief coordination, medical logistics contracting, all separate, all clean, all sharing the same financial spine. Behind the corporate filings were 53 bank accounts arranged in rotation. Funds never stayed still. Reimbursements flowed into primary accounts, dispersed into layered sub-accounts, resurfaced weeks later as vendor payments, charitable grants, overseas program transfers. The numbers should have signaled instability, yet the movement was calm, measured, uniform. Like a machine executing a cycle. Over 4 years, analysts tracked more than $124 million moving through the network, not as profit, as momentum. The structure became clearer when investigators overlaid the financial web onto the logistics map recovered during the raid. Every major transfer coincided with contract payments tied to temporary staffing, transport coordination, youth outreach shipments. These weren't random expense labels. They acted as bridges, allowing significant capital to flow into freight schedules without triggering transactional suspicion. And then there was the timing. Every time one company filed reduced revenue statements or paused operations, another entity activated within weeks, inheriting vendors, contracts, reimbursement eligibility. On paper, it looked like a struggling sector replenishing itself. In practice, it meant the operation never truly paused. It simply changed uniforms. Comment system. If you understand this wasn't one crime, it was infrastructure. The chilling effect spread fast. The discovery of the network should have brought clarity. Instead, it introduced uncertainty, not about what had happened, but about whether the state could still hold any of it together. Inside prosecution offices, the reaction wasn't celebration or vindication, it was silence. Not because evidence was weak, but because precedent had already been set. A unanimous jury verdict had vanished in a case the state believed was among its strongest. And now, every attorney working fraud, financial crime, contract abuse was forced to confront the same question. If this case couldn't stand, what could? 9 pending prosecutions built on similar evidentiary models were paused. 3 more, once slated for trial, were narrowed into reduced filings to avoid the risk of another collapse on appeal. Younger prosecutors stopped describing charges as solid or slam dunk. They started calling them fragile. The hesitation was subtle at first. Timelines stretched. Charging memos grew thinner. Investigators were asked to remove sections that relied too heavily on pattern analysis, even when those same patterns had historically constituted standard proof in white-collar cases. No one said the words out loud, but everyone understood the implication. It wasn't just about winning a trial anymore. It was about surviving the bench. Afterward, defense attorneys noticed the shift immediately. Motions challenging circumstantial inference multiplied. Expert witnesses were reframed not as analysts, but as interpreters of behavior, arguing that any alternative explanation, no matter how improbable, was enough to fracture accountability. The chilling effect traveled fast. Community advocates expected outrage over the fraud revelations. Instead, they faced confusion. Some residents saw the overturned verdict not as a procedural anomaly, but as validation, proof the system could not be trusted to prosecute fairly, consistently, or at all. Others feared the opposite, that the state hadn't lost control of its cases. It had lost control of its confidence. Type confidence. If you believe hesitation destroys justice, federal intervention became inevitable. By the time hesitation reached the courtroom, federal agencies were already past it. To them, the question was no longer whether the state could hold the case, but whether the consequences of letting it fracture any further were tolerable. They decided they weren't. The first sign came quietly, a Treasury compliance notice, sent not to a single business, but to the entire constellation of entities tied to the financial lattice. Within 48 hours, 312 accounts were frozen under Provisional Review Authority. Vendor lines suspended, payroll systems halted mid-cycle, overseas transfers stalled in transit before clearing destination banks. None of the notifications mentioned fraud. They cited national financial security safeguards. The move wasn't theatrical, it was structural. Where state charges had tried to prove harm, Federal Review treated the network as an active risk vector. Every lease, every contract, every logistics invoice that touched a cross-state carrier was flagged for parallel classification under wire fraud, narcotics conspiracy, false claims, interstate transport violations. The language shifted, and with it, the leverage. The same activity that once lived inside a narrow prosecution frame was now measured against federal thresholds. Transaction batches that once appeared ambiguous under circumstantial interpretation now triggered mandatory escalation because they intersected with regulated corridors and export codes flagged during the warehouse sweep. And then the footprint widened. Case analysts traced residual capital routes into nonprofit advisory boards, regional coalitions, humanitarian exchange programs spanning 4 states. Not every entity was complicit, but enough overlap existed that the network no longer resembled a scheme built around a single pair of defendants. It resembled an ecosystem. That's when IC stepped in, not as immigration enforcement, but as a residency eligibility auditor. Files linked to benefit qualification, travel waivers, sponsorship affiliations were cross-matched against Treasury block records. The review wasn't accusatory, it was diagnostic, designed to map who had lawful access to what and which pathways could still enable regeneration if prosecution stalled again. Meanwhile, FBI financial crimes units took custody of the logistics chain, not as evidence, as infrastructure. Freight partners were notified that future contracts associated with suspended entities would trigger federal routing review. Third-party contractors received compliance advisories requiring disclosure of subcontract layers once considered too minor to report. Carriers that once operated in shadows of ambiguity now faced a binary condition: declare or disconnect. It wasn't punishment, it was containment. Behind the scenes, federal prosecutors assembled dual-track options. One civil, one criminal, allowing the government to seize assets tied to narcotics facilitation, even if state-level criminal outcomes remained uncertain. The goal was no longer to prove intent in a single courtroom. It was to remove capacity across the system. For the first time since the verdict vanished, momentum shifted, not because facts had changed, because jurisdiction had. The network had thrived in the space between agencies, in the hesitation, in standards that fractured, in the slow erosion of confidence. But once the case crossed that line, the frame closed around it, and the message, spoken nowhere, understood everywhere, was unmistakable. If the state could no longer hold the line, the federal government would. Comment federal if you support intervention when state systems fail. The deeper question remained. Federal intervention didn't end the crisis. It exposed where the true fault line had always been. For years, Minnesota's fraud cases had existed inside a narrow frame, individual defendants, isolated prosecutions, verdicts that lived or died based on how a single courtroom interpreted circumstantial control. But when the network shifted into federal custody, the story no longer revolved around one judge, one case, one overturned verdict. It revolved around a deeper question: who controls accountability when the system itself becomes the variable? The appeal moved forward, not with urgency, but with gravity. Legal scholars who had once debated evidentiary thresholds now confronted a far more uncomfortable reality. The standard that erased a unanimous jury verdict had not merely destabilized one case, it had created an escape hatch, one that others could follow. Defense teams across the state began citing the same reasoning, not to argue innocence, but to argue uncertainty. Every missing record became a hypothetical alternative. Every financial pattern became a possible misinterpretation. And for the first time, courts were forced to confront a paradox that had never been designed for cases of this scale. If accountability requires absolute proof of intent in crimes built on distance, hierarchy, layered control, then who exactly can ever be held responsible? Federal analysts had an answer. The network had never relied on one decision maker. It relied on separation, titles divided from actions, paper owners divided from operational control, compliance language divided from logistics reality. The system didn't collapse because the criminals were invisible. It collapsed because the structure they built looked too much like the systems meant to regulate it. In Washington, briefings shifted tone, not emotional, not political, clinical. The case was no longer cited as a fraud failure. It was cited as a governance failure, a warning about how complex financial ecosystems can exploit judicial standards, never designed for multi-layered criminal infrastructure. Policy committees began drafting proposals, stricter circumstantial thresholds in high-scale financial crime, expanded federal-state joint jurisdiction triggers, automatic escalation for benefit fraud tied to logistics corridors, new review authority for philanthropic and humanitarian export codes. Not reform as punishment, reform as reinforcement. Meanwhile, inside Minnesota, the divide grew sharper. Some residents saw federal involvement as intervention, others saw it as indictment. To them, the most painful part wasn't the money, or the warehouses, or the networks stretched across states. It was the realization that the case didn't fail because no one was watching. It failed because everyone assumed someone else would hold it. Type accountability. If you believe systems must be stronger than hesitation, the lesson matters most. The federal freeze orders stayed in place. The accounts remained suspended. The corridor was dismantled, not through a verdict, but through removal of capacity. And yet, inside the quiet of the courthouse, one truth lingered. A system can survive fraud. What it cannot survive is hesitation, because once doubt becomes part of the process, every verdict, every ruling, every case that follows must first answer a question that was never supposed to exist. Not was the crime committed, but will the system be allowed to say so? This case revealed something every citizen should understand. Justice doesn't fail when criminals are clever. It fails when systems hesitate, when precedents create escape hatches, when confidence erodes from within. The network in Minnesota didn't succeed because it was invisible. It succeeded because it operated in the space where accountability fractured. Federal intervention closed that space. But the question remains, how many other corridors exist in states where federal jurisdiction hasn't yet arrived? How many other verdicts have quietly vanished? How many other networks are thriving in the hesitation? I want to hear your thoughts. Do you believe federal intervention was necessary? Should states have stronger standards for complex financial crime? Tell me in the comments below. Your voice matters. Your engagement helps this investigation reach others who need to understand what happens when systems hesitate. If you support accountability over hesitation, hit like. Share this video. Let more people see what happens when justice pauses. And if you want me to keep exposing cases like this, type continue in the comments. Because this operation may have ended, but the lesson it taught is just beginning to spread.